I want to talk to you about closing arguments in immigration court. Closing arguments in immigration court have an important part of your overall individual hearing, so I'd like to put its importance in proper context. There are three rules to remember. Number one, never waive it. Never waive your closing argument in a contested individual hearing. At the close of your case, after you rest, the immigration judge may ask you, as if it's an optional matter, if you'd like to provide a closing argument. Well, I will tell you, please never waive your closing argument. It's the time when the immigration judge, maybe for the last time, will judge you on your command of the case. Number two, be prepared to be interrupted. Be prepared to be interrupted when you provide your closing argument. At the beginning, in the middle, at the end, be prepared. In fact, don't look at it as an interruption. It is very common, unlike in criminal or civil matters. Being stopped in the midst of your closing argument is a common mechanism and common in most immigration court proceedings and done commonly by the immigration judge. Don't look at it as an interruption, in fact. Look at it as you providing an oral argument, for example, before the circuit courts. I practiced before an immigration judge on the bench and now retired for over 30 years. And I will tell you, he interrupted me every time I provided my closing argument. After talking to attorneys about this, I learned that he did this with almost every case. Again, permitted under the rules, and it was his fact-finding methodology. So be prepared for that. Be prepared to be interrupted not only by the IJ, but also interruptions are very common by the government attorney. Incorporate these things into your closing argument so you don't feel like you're thrown off or knocked out of your stream of consciousness and upset, and where you lose your train of thought. It's part of the fact-finding process and very common in immigration court proceedings. Last but not least, rule number 3. Provide appropriate BIA and appropriate Federal Circuit case law that supports the testimony and the evidence provided in your case. Remember that this is the time that you are attempting to convince the IJ of the merits of your claim and how the case should be granted. So you need to provide appropriate case law that does this and provide the citation for the transcriber. Immigration judges in judge school are provided templated decisions to grant your client's case and also to deny your client's claim for relief. You also should provide appropriate BIA and relevant circuit case law that supports the testimony given and also the evidence that's been presented in your case. For example, where battery is an essential element of your claim for relief, I had a case where battery was proven in the case, however, the government was attempting to minimize it. In my closing argument, I defined what battery is. In Illinois, it's defined as an unpermitted touching. So even though there are different levels of battery, battery nevertheless is battery. So if there is an unpermitted touching that has occurred in your case, battery has been proven in your case. Similarly, in the asylum context, you may need to argue the nexus requirement and again provide appropriate BIA case law and appropriate and relevant Federal Circuit case law that supports the arguments and the evidence that's been presented in your case. Remember these 3 rules and you are well on your way to providing a winning argument in immigration court.